Well, hello, everyone. It looks like we have a real nice group of attendees, and thank you for joining our webinar today entitled The End of Clinical Wellness Incentives. My name is Mark Delicave, and I work at Quizify, and I'd like to introduce our panelists today. And the first person being Al Lewis. And Al is the CEO of Quizify, and he's one of the foremost authorities in wellness and population health. Many of you know and have talked with Al before. He's authored a book specifically about wellness outcomes analysis entitled Why Nobody Believes the Numbers. And in that book, he goes into case studies and different companies and what they're doing with their wellness programs and whether the outcomes are valid or not, and another analysis of the ROIs as well. In addition to that, Al wrote a book in 2013 entitled Cracking Health Costs. And he wrote that with Tom Emmerich, and Tom managed benefits at Walmart for more than a decade. And as most of you know, Walmart is very much on the forefront of employee benefits. And in that book in 2013, they talked about centers of excellence, about better pharmacy benefit management, better medical management. Many of these things are now going mainstream in next generation healthcare programs. So Al's going to be leading our discussion. In addition, he also has a law degree from Harvard. Now, in addition to Al, Barbara Zabawa has joined us today. And Barbara is the founder and president of the Center for Health and Wellness Law. And this is a company that's dedicated to improving legal access and compliance for the health and wellness industries. Now, Barbara has a book out on actually workplace wellness programs. And Al and Barbara will be leading our discussion today. And Barbara actually is ready to produce another book.
Mm-hmm. Yes, the second edition is coming out this year through the American Bar Association of the Rules of Workplace Wellness Program.
Yes, and the fact that you are on this webinar means that whether you like it or not, you will be notified when it comes out. And I'm sure it'll be very good. I reviewed the first, gave it 5 stars.
Thank you.
Okay, so we have to do our little disclaimer here. This webinar does not constitute legal advice, yada, yada, yada. All right, there's been a lot of news lately, big news, and actually most people haven't caught up to it yet, which is why this webinar has so many people on it. We're going to go through why the recently proposed EEOC rules are already dead and what the governing law is now, and then we'll get to the rest of it. Put your questions in the chat box or text them. The chat box seems to already be filling up here. You probably, oh my goodness, and the text box seems to be filling up. We will get to the questions eventually. Barbara, I will put my glasses on and read the text box while you go through where the rules are now.
Right. So welcome everyone. The EEOC is the federal agency, of course, that enforces compliance with the ADA and GINA. And the EEOC came out with rules in 2016 that tried to put some definition around the statutory requirement that wellness incentives that collect employee health information be voluntary, or part of a voluntary wellness program. And the 2016 rule said that you could incentivize the collection of employee health information, which is often done through traditional health risk assessments or biometric screens, at 30% of the total cost of employee-only coverage, up to that amount. And the AARP sued the EEOC almost immediately after those rules came out in 2016, and the AARP prevailed. They sued and said that the 30% incentive limit was arbitrary and capricious, and the court agreed, and so told the EEOC to eliminate that 30% incentive limit as of January 1st, 2019. Since then, we have been waiting for the EEOC to come out with revised rules to put a different number, perhaps, around that word voluntary, which again is in statute and is not going to change. And finally, earlier in January 7th of this year, the EEOC came out with some draft rules that we're going to be talking about. And unfortunately, they never published those rules in the Federal Register. So that was a big hint that things might not be going as planned by the EEOC. And then once the Biden administration took over on January 20th, Biden administration sent a memo to all federal agencies to freeze all rulemaking, especially the ones that had not been published yet in the Federal Register, which would include the ADA rules on the new rules that were proposed on January 7th. And another big change at the EEOC on January 20th was that President Biden appointed Commissioner Charlotte Burrows to the chair of the EEOC. Now, Commissioner Burrows, she was the most vocal about opposing the draft rules that came out on January 7th of this year. She did not like several elements that were being proposed. We feel that her leadership role now as the EEOC chair will definitely have an impact on whether the rules that were issued on January 7th ever see the light of day.
Okay, thank you, Barbara. And we're already getting overwhelmed with questions here, but the one question seems to be coming up all the time. Yes, the slides will be shared. Yes, the recording will be shared. Okay, so to Barbara's point, it's the same commissioners in the EEOC as at the beginning of January, but they've switched the reporting, and switching the reporting makes all the difference, as anybody who watches The Office knows, right? That it's a lot different when Ryan reports to Michael G. Scott than when Michael G. Scott reports to Ryan. That's basically what has already happened. So Barbara, do you want to go through the safe harbor while I try to catch up yet again on the chat box here?
Right. So one of the issues that was proposed on the January 7th rules release that was never published in the Federal Register was that all group health plan, health contingent wellness programs could be exempt from this new incentive limit that would apply to all the other types of programs, participatory, whether they're in a group health plan or not, that collect employee health information from this new de minimis wellness incentive limit. That's what the EEOC was proposing to replace the 30%, was this de minimis standard, except for wellness programs that fell within this insurance safe harbor. And it was really interesting to see the about face that the EEOC took with regard to this insurance safe harbor. The insurance safe harbor has existed since the beginning. And what it is a provision that allows health insurance, group health plans to be exempt from other restrictions under the ADA when it comes to information collection, because the ADA allowed these health plans to use health information collected from enrollees to help underwrite risks, administer risk, and classify risks. And that provision was actually used by several lawsuits pre-2016 to help justify imposing really high incentives on group health plan wellness programs that were collecting employee health information. And the EEOC, when it came out with its rules in 2016, was in response to those lawsuits, said, we don't think the safe harbor, the insurance safe harbor, should apply to any wellness program, regardless of whether it's part of a group health plan. And then in its January 7th, 2021 rules release, it said, oh, you know what? It's okay for the safe harbor to apply to group health plan wellness programs that are health contingent. And in that case, in those types of wellness programs, they would be exempt from this de minimis limit. They could go impose incentives that were much higher, and they would be, of course, restricted by their incentives through the Affordable Care Act, because, of course, as group health plans, they would be subject to the Affordable Care Act wellness incentives, which we know are up to 30% of the total cost of coverage, or 50% if it's tobacco related.
Okay, so question just came in about the difference between the so-called health contingent, outcomes-based, and participatory. And January 7th, it looked like there was going to be difference, but now we think there isn't going to be, right?
Yes, because of the change in commissioners, because that was one of I mentioned when Commissioner Burrows was objecting, but very strongly to the rules back in when they were first proposed. One of her biggest objections was this revival of the safe harbor, the insurance safe harbor for group health plan wellness program. She did not believe that the safe harbor should apply to any wellness programs, and was very opposed to bringing it back for group health plan wellness programs.
Okay, thank you. And I'm going to just skip a few slides because you actually said them, which is too bad. There's some clever visuals on them. So to summarize where we are now, there are no rules that expansively interpret the word voluntary in the ADA. And Barbara, as you said, if there is a law, and this is true with any law, and there's no regulations or anything interpreting the law is taken on its face.
Yeah.
Now, most clinical programs, clinical, not activity-based, have been in technical violation of the ADA for 2 years, just like all except 3 registrants for this webinar. Now we have, actually it's now 882 or something, but I looked at 40. You know, my Ambien wore off very early this morning. So I looked at 40 of the employer programs here where the wellness was very easy to find online, and only 3 of them were in compliance. Now you might say, well, don't we have some time to get in compliance? Yeah, you had 2 years. So Barbara, can you sort of summarize what Judge Bates said in January 2018 about when the safe harbor was going to disappear?
Yeah, so the safe harbor, not the insurance safe harbor, but the 30% incentive limit that was in effect starting in 2016 was eliminated as of January 1st, 2019. And there was a time lag between that deletion of that limit, because the judge understood that a lot of wellness programs were, already planned for the following year, which would have been in, I think, 2018. And so the safe harbor, well,
yeah. I'm sorry.
The incentive limit was officially deleted from the law books, if you will, on January 1st, 2019. And then since then, we haven't had any other replacement.
So you might ask, if you've been in violation of this, which 90% of you have for 2 years, how come you haven't been pulled over yet? Well, the answer is, and we'll use a car analogy here. If you're driving 75 in a 75 mile an hour zone, you're fine. If they reduce the speed limit to 65 and everybody's still driving 75, you're fine. But now, number one, they've reduced the limit to 55. And number two, when the limit was 65, there was one program that was going 85. And they got called out, they got sued. And as a Harvard grad, I got to tell you, could not have happened to a nicer bunch of people. It was the Yale program. And so that's what we will discuss next. It's kind of a time bomb. It doesn't just affect Yale, it affects everybody on this call. Just to summarize, it was not an outcomes-based program, which you would have expected for the test case. It was participation. And Barbara, I believe there was actually 4 figures of income at stake here.
4 figures of income?
Meaning
sorry, I was
1,000.
reading one of the questions.
Oh yeah, I know, it's hard to do both. Well, yeah, it was $1,250.
Yes.
Yes.
Yeah, annually. It was a $25 payment out that you had to make, and it ended up being, or was it a deduction out of your income? And over the course of the year, it was like $1,200 or $1,300.
It was a lot of money. And what they did, which was very slimy, was they did not apply this wellness program to the people who could fight back, meaning the professors, because they saw what happened at Penn State when the professors fought back. They only did it to the hourly workers. So it was a sort of a two-pronged system. And if you want to know why Charlotte Burroughs doesn't like these programs, one reason is that they're discriminatory against wage-earning people generally. But fortunately for Yale, their employees were unionized. And so the union got involved. It also, unfortunately, helped. It unfortunately helped that the quote-unquote coaches for these vendors did some cringeworthy things. And the best example is that they just hectored, they browbeat a woman into getting a mammogram who had already had a double mastectomy because she was a cancer survivor. So if the coaches had had their way, she would have they had a fine on top of having had cancer. So this is why you can't just trust coaches to have conversations with huge fines involved. So the AARP got involved with the unions and they sued. Now, Barbara, why don't you do the last point here, because you've been a little bit closer to it than I have.
The guarantee of summary.
No, we'll do the guarantee.
Oh, okay.
So the judge.
Oh yeah, yeah. So right now the status of the case is that we're waiting for the judge to make a decision. The plaintiffs and the defendants both submitted motions for summary judgment, and the last court filing for that was in July of last year. So anytime really we could expect a decision from the court to decide if the court's going to agree with the plaintiffs or the court's going to agree with the Yale University, the defendant, on whether this was in violation of the ADA.
So in the immortal words of the great philosopher Yogi Berra, it's tough to make predictions, especially about the future. However, Quizify is actually guaranteeing summary judgment for the plaintiffs, and you can link through on what this guarantee is, but basically we're saying that the plaintiffs are going to win, and if you sign up for Quizify between now and when the decision comes down, based on our say-so, and we're wrong, you get double the contract length, okay? Now, Barbara, I tend to be a little edgy on these things. Maybe you want to hedge a little or not?
I read the brief that was submitted by Yale University, and I thought they did a good job. They focused on, the fact that, as you point out, Al, the plaintiffs were part of a union. And according to the Yale University, the union bargained for this wellness program because in exchange for the wellness program, they forewent any increases in premium or cost sharing by the plaintiffs. So the decision was made by the union that we'll take the wellness program and the incentives over having to have our union members pay more in their health insurance premium or other cost sharing as part of the plan. And so that, according to Yale, was the choice that was given. And, as members of the union, the defendants point out, you don't always get to like everything that your union does, but you belong to the union because overall, it advocates on your behalf. So that's really the strong position that they're taking in that case.
Well, that's very interesting. And I had read the plaintiff's brief very carefully, but it serves me right not to have made this guarantee without having read the defendant's brief. If in fact that is the ruling, we're still stuck. So if you want to sign up for Quizify, now's the time to do it. Now, if in fact this ruling is for the plaintiffs, as I still expect it will be, just with less certainty based on what Barbara said, you have to know that there's a whole plaintiff bar out there with all sorts of lawyers just dying to get their hands on a big class action here. They're complex, so it's not the mom and pop lawyers, but they're dying to get their hands on these sharks. This is what they do. And one of these sharks could come after you. So you want to be in compliance. Now, so that's all the bad news, but there is some good news, which is that you can turn this existential lemon into existential wellness lemonade. So you want to talk a little bit about how you can actually, it's not a technical safe harbor, but how you can kind of become your own safe harbor here?
Yeah, so the word voluntary, again, there's no definition for it, but obviously the more choices that you offer in your wellness program, the more voluntary it's going to seem, depending on what people choose. If they know that they have alternatives to earning an incentive, that's not going to feel as coercive as if they were only offered one avenue. Offering activity-based programs, lunch and learns, those kinds of things as alternatives to your wellness incentive, that's really important as far as giving the feeling or perception that your wellness program is more voluntary.
So we got a comment in that says you can't bargain away, a union can't bargain away their employees' civil rights. So now I'm feeling better about my guarantee.
Yeah, well,
So
that's the crux of the case.
That's
though.
the crux.
If are there civil rights violations by the way that wellness program was set up?
So let's take what you just said and have a couple of examples here. This is an example of an organization. This is their actual thing. You don't actually have to read it, but I'll just, because I'm going to make it clearer in a minute. This is, you can earn up to $500 by meeting some combination of the goals that they put here. Now you might say, wow, $500, this is cool. You know, and why are people who are, you know, pro-employee, like I would claim to be, and I imagine you would, so upset about things that give employees money? Well, the answer is that the reason these incentives got to be so high was that employers would skinny down the health programs, not unlike in the Yale example, and say, don't worry, you can earn it back if you do these things. So the judge in the original AARP v. EEOC lawsuit did not distinguish between incentives and penalties. And in the immortal words of the great philosophers, the undisputed truth, a smile is just a frown turned upside down. The judge actually cited that song in his ruling. No, he didn't. I'm just making that up, just to make sure you're paying attention here. All right, so let's take that table, and I just wanted to show you, make sure you knew it was real. And now let's sort it into clinical activities clinical versus activities. So the first 5 are clinical: the coaching, the you know, getting your weight down temporarily, the health risk assessment, the biometric screen, and more losing weight. And there's all the money you can earn up to $500. There's 2 activity-based programs, and Barbara mentioned, I'm sorry, did I say smoking for the first? I meant coaching. Barbara mentioned that lunch and learns are, you know, a popular activity. The thing about these activities is that they don't add up to $500. So this program is out of compliance. Now, one of the questions that's come in several times is when it's a smoking thing, is nicotine testing permitted, or can you just ask people? And Barbara, I'll let you clarify that one.
Yeah, the EEOC has said that if you're just asking people if they use tobacco, that's not a disability related inquiry, which means that that question wouldn't be subject to the ADA rules. But testing for the presence of tobacco would be a medical exam, and that medical exams are subject to the ADA rules, and therefore any request to undergo a medical exam, tobacco test would be subject to the voluntary requirement under the ADA.
So you can ask, but here's a news flash for you. If you ask people whether they smoke or not, and they get $250 saying they don't smoke, trivia question, what is the answer going to be? You do not have to run a trivia company to know what the answer is going to be. Merely look at your own numbers. You will see that about 5% of your employees smoke. Say they smoke when in reality about 18% do. So now let's make this program compliant. Okay, so we actually have a question about online coaching. Let's say, yes, these are all, okay, so these red ones are clinical. The red ones, it is possible, as we'll see later, to make coaching non-clinical. It's just very, very hard. But let's focus on the ones that we know to be non-clinical, the lunch and learns and the smoking. So they add up to $350 because you're doing 4 lunch and learns. Now, you could become technically compliant by making people do, or giving people the an option to do 10 lunch and learns. Suddenly now you can earn your $500 by non-clinical things, right? However, you got to start thinking about your employees here, okay? Because you're basically asking them to take 10 hours to sit through stuff. They're only doing it for the money. And that's gonna poison your relationship with the employees quite a bit. And also you have to think about their relations with their supervisors. Their supervisors are gonna be wanting them to do their jobs. And you're saying, we want you to do this. So it creates tension between you and the supervisors, between the employees and the supervisors, and so on. And as for the claim for not smoking, well, you're trying to create a culture of health. If you just let people say they don't smoke, you're creating a culture of deceit. Why is completing a risk assessment considered clinical? Because you're asking people things like, do you have diabetes? And we can't possibly get to all the questions that are coming in. So I'm not going to try to interrupt myself anymore here, unless it's if you think it's very, very relevant, use the text that we put at the beginning, if you remember what it is. And I know a few people do, because I'm getting a few. So now it's time for the 60-second Quizify shameless plug. And if you thought you were going to get through an entire webinar with the world's greatest self-promoter running it, you got to think again. But I will try to keep it to 60 seconds. So Quizify was purpose designed specifically because we knew this rule change was going to take place following the election. Now you might say, wow, these guys are really prescient. No, we actually thought it was going to be election of 2016. So we were wrong by 4 years. This single page puts you in compliance, because if you look, the word choose, choice, and choose are down here. So it's very clearly voluntary. We do suggest, and I myself do get screened, I'm 64, I get screened every few years voluntarily. We do suggest that people who should be screened get themselves screened, but voluntarily. And we use the choosing wisely guidelines to say who should be screened and who aren't. If you screen everybody every year, you're going to get vastly more false positives than you're going to get actionable things. Alternatively, they can play the Quizify games, the quizzes, the 10-question quizzes on a variety of different topics. And the quizzes will teach employees what they need to know about health and healthcare and health benefits. They'll actually engage the employees. We will also indemnify. We will say this is compliant, period. All right, done with the shameless plug. Now let's go through interpreting the rules and exceptions, and get ready to hit your buzzers, because we're going to get to the polling questions. So what happens if you try to make HRAs non-clinical? Well, they either have to be clinical and voluntary, or you have to rewrite them so there's no medical inquiries. And it's virtually impossible to do both. So hit your polling, and we're going to ask a polling question. And then you're going to put in the answers. And while you're answering, I'm going to answer a couple more questions that have come in. And then we're going to turn it over to Barbara to describe the right answers here. So there's two. How often do you feel down in the dumps? Do you want information about diabetes? How much do you drink? Are you comfortable with your weight? So polling is about to go up. And while it goes up, I'm going to take some more questions here. I'll take a couple that have come in off the text. Should we do wellness at all? Yes, absolutely. You should have a wellness program available to people who want it that is compliant with USPSTF guidelines. People think I'm against wellness, and yet I get screened, right? So I love wellness, but only appropriate wellness. Do we have time for one more, or do we have an answer coming in? Oh, we got the answers. So which two statements, and how much do you drink, and how often do you feel down in the dumps? One survey says, and what is the actual answer, Barbara?
A and B, yeah. And we said these are the answer because one, down in the dumps suggests depression. What you want to do, I mean, if you're trying to avoid disability-related inquiries, you want to avoid trigger words or clinical diagnoses that you're trying to get people to answer questions on. And so down in the dumps can be interpreted as depression, and they're asking how often do you feel? So you're trying to get an idea of if people are clinically depressed. And then the second choice, letter B, references the word diabetes. I help a lot of health coaches and people who work in the alternative and complementary care space. And one of the things that I try to counsel my clients on is to avoid trigger words. If you're doing coaching and don't want to be perceived as offering clinical types of services. And diabetes is certainly one of those trigger words because it's a diagnosable condition. And so even though people might want information about diabetes, if they're answering that question in the affirmative, there's a good chance that they have been diagnosed with diabetes or have family members who have diabetes, and that could be perceived as a disability-related inquiry, and then therefore taking you into the jurisdiction of the ADA voluntary requirements.
So let me add a couple things to that. The question that people voted for was how much do you drink? And I would draw a line between that and have you been diagnosed with substance abuse or are you alcoholic? What do you think, Barbara?
I mean, I looked at that one and said, hey, that's possible. That could be interpreted like the first one. How often do you feel down in the dumps? How often do you drink? You know, trying to get an idea if people are, you know, alcohol or, you know, suffering from alcohol addiction, which is a clinical condition again too. So it's arguable. It's arguable.
Yeah, honestly, if it's me, I say that's perfectly okay, but you can easily cross a line. And even the, you know, the diabetes word is a trigger word. It doesn't automatically make you non-compliant. It's just that plus a whole bunch of other things might get you in some trouble. We've had a couple people say, describe their programs and say, well, mine sounds like it's compliant, where the answer is no, it's not compliant. 90% of you folks have non-compliant programs. It's very simple. Are these programs largely clinical? Can you get to an answer? Can you get to all the premium differential or whatever without any clinical inquiries? Now, here's what happens when you try to write an HRA without clinical inquiries. This is an actual question from the most widely used HRA. So if you think you've seen this before, it is, as in the immortal words once again of Yogi Berra, deja vu all over again, because you have seen it before. Do you agree with the statement, I am a good person, live a good life? Well, everyone who's a good person is going to put a 7 on that, strongly agree. But here's the thing, here's why it's not a particularly good HRA question, because the whole point of being a bad person is that you lie and you cheat and you say that you're a good person. So this question is worthless. So the irony of the HRA is that if you start asking questions that are useful, they suddenly become clinical. And if you don't, they're not useful. So let's go through a couple more. I'll give a couple more examples, and then Barbara will turn it over to you for another rule-related trivia question. It's perfectly okay to do how many vegetables do you eat? Not okay for are you depressed? The risky word we talked about, would you like information for diabetes? It's clearly not okay to ask people if they have diabetes. Mm-hmm. And then Barbara, why don't you talk briefly about weight control here?
Yeah, so weight control in my mind, doesn't necessarily evoke clinical conditions. It's not really a trigger word. In my mind, I think, you know, a lot of people who do not have any clinical conditions want to maintain, you know, a healthy weight. It's more of a lifestyle kind of, could be couched as more of a lifestyle kind of question, as opposed to are you obese, which is a clinical condition, or what do you weigh, is, you know, trying to get more exact numbers about, you know, what your weight is, and then that could lead to, you know, conclusions about your health condition. But weight control, you know, even very healthy people may be very interested in knowing how they can keep their healthy weight.
So once again, a whole bunch of questions are coming in, but let me just do 2 relevant ones right now. Somebody asked, if we do a biometric stream but don't judge people on the results, that is out. If that's the only way people can earn their incentives, out. Then we got, should we do HRAs at all? Honestly, you're talking to a guy who gets himself screened, right? And if I wanted to do a health risk assessment, I wouldn't do it through my wife's employer. I would simply go online and do a health risk assessment. There is absolutely no reason to ask to do health risk assessment, because the people you're trying to find are going to, frankly, lie. And if you don't believe me, just look at your numbers. You should have 70% of people drinking, 10% drinking heavily, 18% smoking, and you don't. Okay, let's do another polling question. Which is not a clinical exam or inquiry? Coaching, checkups where you have to give results. This is with a doctor, this is not screening. Checkups where you just have to prove that you got one. And all of the above are clinical inquiries. And meanwhile, we will do one more. Can we fine employees for anything? Well, yes, of course you can. Like if you have, say, a company car, and you say people can use it on weekends, but if you crash it, you have to pay us $2,000. Yeah, this not being able to find employees thing only relates to clinical inquiries. So do we have some answers here, Mark? Okay, all of the above are clinical inquiries. Barbara, take it away.
Yeah, good job. I would agree that all of the above are inquiries. Because one, with coaching, you necessarily ask people health-related questions, otherwise the coaching doesn't really benefit anyone if you're coaching in a vacuum. So you're going to have to know some health information from the people that you're coaching. And then the checkups, yes, of course, if you have to turn over your results, that is, of course, disclosing personal health information to your employer, and that is covered under the ADA as a disability-related inquiry and a medical exam in both instances, because you're asking people to go get a health checkup, which is why the third option is when you have to go to the doctor, but you only have to bring back proof that you got that you had a checkup, is also considered covered under the ADA and subject to the voluntary requirement as a medical exam. I spoke with Chris Kuczynski, who is the attorney for the EEOC and wrote the 2016 rules, and asked him, having an employer ask an employee to go see their doctor and offering an incentive to go do so, subject to the ADA voluntary requirement. And he said yes, because that is a medical exam. And going to see the doctor is a medical exam, and it would need to be part of a voluntary wellness program.
So let me add a couple things to that. One is that the doctor, if you are not hitting your numbers and the doctor is supposed to send something in that gets you fined or loses you your incentive, they're actually violating their Hippocratic oath. There is an article in the New England Journal of Medicine about that, how a doctor can't serve two masters. They can't be truly a patient advocate, truly trying to help their patient, but also turning their patient in. So I would take checkups off the table. And then somebody actually wrote and asked, aren't checkups free? Yes, they are free. And you can tell people, go get a checkup, please get a checkup. But you can't attach money, fines, premium differential, anything to those things. And in fact, honestly, people shouldn't be getting them. The large majority of people probably shouldn't get them every year anyway. The right frequency for checkups is when you go to the doctor and you have a checkup, and let's say it's a good checkup, you say to the doctor, when should I get my next checkup? And they'll say 2 years, 3 years, 1 year, 5 years. That's the way to do it, because who knows better than your doctor? Okay, so this is my favorite example of the bright line between activity-based and clinical. It's perfectly okay to tell your employees to run around the block, and when you get to the other side, assuming drop dead or something, you get to the other side, we'll give you money. That's perfectly okay. But if you say run around the block and we will take your pulse and give you money, that's clinical. So there's the distinction right there between activity and clinical. So let's talk about crash dieting contests, a weight loss contest that a lot of people do. So Barbara, take it away here.
Sure. Well, so weight contests are, of course, you're asking people to give their weight, and that's inherent in the activity. So that would be subject to the ADA voluntary requirement, because you're asking people for health information, and which is including their weight. But also, an important consideration is a lot of these contests are not done under the supervision of licensed professionals. And so as an employer, who sponsors these programs, I would really question the safety of those kinds of activities, because unless a licensed physician or licensed dietitian or someone with clinical expertise on who should be losing weight, given all the other, circumstances that they may have in their life, other conditions, medications and things like that, it could be very legally risky to have these kinds of programs.
And I would add to that, we're not really going to go into it, but we left the links. People cheat and they harm themselves. And in fact, in my personal blog, I've gotten about 400,000 hits on all my blog posts combined. About 80,000 of those hits are how to cheat in a corporate wellness program, which was supposed to be tongue in cheek, but people find it on Google. And I quoted some people who are experts in cheating, and they talk about this horrible stuff that you do to yourself to get your weight up and then get it back down again. So I would just take those off the table regardless. So we're getting some great questions. I think we're just going to have to save them to the end because they're just too many. I just can't keep up with. And Barbara, why don't you now go into what is okay with the value-based design?
Yeah, so there is a provision in the HIPAA statute that allows health plans, group health plans, to discriminate in favor of people with medical conditions. Now, assuming you gather information legally about people and are able to identify them legally that might have clinical conditions like diabetes or others, you could incentivize those individuals, give them a greater benefit to help them address those clinical conditions without, violating HIPAA, for example. So that's called benign discrimination. Again, it applies to health plans, not employers. So that's really important to remember that, you can do that.
As when you say that applies to health plans, not employers?
Yeah. Employer health plans, group health
Employer
plans.
health, yeah.
So it could be self-insured or insured health plans at the employer. Yeah.
There, well, I'm saving a lot of these for the end, or we'll probably have to write later. There are a couple that are probably we should talk about now. One is that, and tell me if I'm wrong, but people say, well, what if they have to give the information to the wellness company and not the employer? I don't think that's relevant. Is it who they have to give the information to?
No, the employer is still, responsible for making sure that, they're in compliance with the ADA. A lot of times I've seen in contracts where the employer is delegating that responsibility to the vendor. And so there may be a contractual liability with the vendor, but as far as compliance with the laws that we're talking about today in this webinar, the employer is the one who has the responsibility to ensure compliance.
So we're getting a lot of questions about, well, this is what our program looks like. Is it allowed? And the answer is, in just about all of them, the answer is no, because unless you can get to the total amount with only activity-based programs, you are technically out of compliance. Now, are you going to get sued? Probably not. There's probably not even going to be the EEOC is not even going to slap your wrist. But the chances are someone in your organization, the CFO, CEO, someone is going to notice and ask you embarrassing questions. So you might as well get into compliance. It is not hard, as we've seen. Quizify would help you do it if you wanted to. So here's another really good question I don't think we were going to address otherwise, which is there are plenty of vendors out there that have nothing to do with actual clinical exams. But if you call and you say you want to go to surgery and they say, well, if you go here, it costs less than if you go here, we'll cover your copay. Tell us about those.
Well, I don't see how that's part of a wellness program. That just seems like it's part of the insurance benefit in a network plan option versus out of network to me, which is different.
Yeah, I mean, the fact that they have to call in is not relevant here. And basically, if that were relevant, then every single call would be a violation. Every single time you had to do UR anything. Yeah, so you're perfectly fine with that stuff.
That's just getting prior authorization, I think. Part of it, yeah.
So let's summarize a couple things. Actually, Barbara, why don't you do this one? I'll read a couple more of these questions coming in.
Sure. Yeah. So people have been asking about. I saw some questions in the comments about COVID-19 shots and flu shots. The EEOC came out with information in December about COVID-19 vaccines, and they basically said employers could require employees to get the vaccine if they wanted, that it wouldn't violate the ADA. It's not considered a medical exam. But as soon as they start asking questions, and this would apply to flu shots as well, as soon as you start asking employees questions about their eligibility for the shot, health-wise, if they have any underlying conditions that might prohibit them from getting the shot or might interact with the vaccine, those questions would be disability-related inquiries. And so if you were going to integrate these shots, these vaccines as part of your wellness program, and you had to ask those questions as part of the wellness program, then you would be subject to the voluntary requirement. And then we already talked about smoking. You can ask people if they smoke, and that's not subject to the ADA. But as soon as you start testing employees for the presence of, chemicals, that would be a medical exam and subject to the ADA voluntary requirement. It's okay to ask about use of alcohol, but not whether you're an alcoholic. Alcoholism, of course, is a condition that is, diagnosable. And then illegal drug use, you can ask, but you can't ask someone if they're addicted to drugs because, addiction, again, is something that is a diagnosable condition that, can get treated by a healthcare provider.
Yeah, and I am shocked at how many HRAs used to ask that stuff and expect people to say, yeah, oh yeah, I'm breaking the law. Yeah, don't worry about it. So once again, we have a ton of questions, but the one in particular, because we have about 30 or 40 on-site clinic folks on this call, and so the question that we're not specifically addressing is, can you give people an incentive to go get their wellness exam on an on-site clinic?
I don't think it really matters. I mean, it's the same as if you were asking someone to get their exam on an off-site clinic. Incentivizing someone to go see their doctor, according to the EEOC, is a medical exam and would be subject to the voluntary requirement.
Yeah. I mean, once again, I don't think anyone's going to call you out on it. Some of these are technical compliance issues. Others are going to get you sued like Yale. And the on-site clinics can be very popular, and they actually can do some good. And well, clearly you can have them, and clearly people can go to them and be encouraged. They just can't be, told like, if you go here to get your exam, it's going to cost. Well, actually, they're free and regardless. So you can't be told if you go here, you can get $50. If you go off-site, it's nothing. All right. So. So there's some very technical questions here too that I think we probably can't answer on the spot, but we'll try we're going to wrap things up a little bit. Then we have one more trivia question, and we are a trivia company, and then we'll try to get to as many of these questions as possible. So just to wrap up, most HREs are either unhelpful or medical inquiry, and somebody like me who thinks that wellness is a good idea still doesn't think HRAs are a good idea at all. Crash dieting contest. I have to tell you a quick story, and we do have the time, and I'm going to name names this time because they were just not very nice. So I have a friend at Schlumberger. Now, mind you, this Schlumberger is a company that should be worrying about whether they're going to stay in business because the price of oil is so low. Instead, every year they do this massive crash dieting contest. And he sends me the thing every year. And for 2 years, I wrote to Schlumberger and very politely said, these are a really bad idea, and here's why. And Schlumberger's reaction was to look at my profile on LinkedIn and try to figure out who I was connected with at Schlumberger who ratted them out on this. Now, I had a feeling they would do this because anybody who does crash dieting contests would do something like that. So we had actually already unlinked. So they will never figure out who my mole is. And by the way, 7 years later, they are still doing these contests, and they actually raised the amount of money involved. So incentivized checkups we talked about, required coaching. If you can figure out a way to do it without actually asking people personal questions, more power to you. Fitness activity is okay with no clinical follow-ups, and value-based designs, have at it. So with that, we're going to go to Q&A, or as they say on Jeopardy, A and Q. And while we're waiting for questions, but I think we've already got
a lot of them.
yeah, we've got way more than we can possibly answer. So I'll just say, to verify, we are asking members to attest whether they use tobacco, but not test. That's an activity. Yes, that is an activity. I have been told that flu shots are considered to be a health plan and need to be treated as such. I don't think so. Barbara?
A health plan?
Well,
So they're probably asking if it's considered medical care and therefore makes flu shot clinics a group health plan. And I don't think they are, because typically for health care or medical care to be considered a group health plan, if you will, the IRS had come out with guidance that is basically tying that with a physician order, a physician prescription, physician involvement, and flu shots don't necessarily need that. Technically speaking, I think there's an argument that it would not be a group health plan. I'll just say that.
okay. So here's a really interesting one. So you offer free flu shots. You have to ask if people have known allergies to components in the vaccine. I mean, that's got to be okay, right? Even though technically it wouldn't be okay.
Somebody's got to ask.
Yeah,
So if it's not the employer, then it would be the health clinic that's delivering the flu shots that would be asking, and that would be subject to HIPAA and all those protections. I see a similar question like about the flu shot and the COVID shot. And I think it's important to understand that if you're trying to integrate the flu shot or the COVID shot into your wellness program, it's going to be subject to the voluntary requirement. And because it's if you're going to be asking people questions, which somebody will. And so if it's somebody at the employer who's asking the questions about whether someone can get this shot because of any underlying conditions, those are disability related questions, and those need to be subject to the voluntary. Not every employer is going to be integrating those shots into their wellness program. And so if you're not integrating into your wellness program and you're just giving out the shot, you can give out the shot and you won't have to worry about the ADA compliance unless you start asking questions. If you start asking questions, then those are disability related inquiries, and you have to be it has to fall within one of the exceptions under the ADA, which could be the wellness program, but it could also be consistent with business necessity and job duties. And if you work in a healthcare environment, especially as an employer, you may feel like everybody getting the COVID-19 vaccine is consistent with business necessity and job duties. So these are the questions that you really need to contact legal counsel to go over if you're planning on trying to require everybody to get the shot.
Well, as Oliver Wendell Holmes famously said, somewhere between night and day, a fine line has to be drawn. So, and I think we're in that fine line area. The other thing that I would notice is that when the New York City cops were really corrupt back in the early 70s, the Serpico days, they divided themselves into two categories: meat eaters and grass eaters. The meat eaters were people who went out and actively tried to be corrupt, and the grass eaters were just people who took the bribes to get along. What the plaintiff attorneys are going to be looking for, what the programs that they just worry about, are the meat eaters, the ones that have large incentives tied to clearly clinical activities. Nobody, technical violation or not, I don't think is going to go after you for a flu shot, even though, Barbara, you're right, there is some gray area there technically, but I wouldn't discourage flu and COVID shots. So we have time for just a few more, but we got more than a few more here. So tobacco surcharge for smokers, including alternative program for those who can't do the program and are exempt with a provider letter.
Yeah.
Maybe we better do that one in writing because that one sounds a little bit more complex.
I don't know what the question was. I mean,
Yeah, I'm having a little trouble. I think I might write back to the person and ask what the question is. We had a couple of questions about the reasonable alternative, and if you have a clinical program, but there's a quote unquote reasonable alternative that is activity based. We're talking ACA, not ADA.
Yeah. You have to have so you have to have a reasonable alternative if you're a group health plan wellness program.
But here's the thing, if somebody can't do the clinical because of some medical disability, unless it's Quizify or something, how are they going to do the activity, right? Maybe the activity is lunch and learns.
Yeah. I mean, you have to come up with a reasonable alternative standard if they can't do it. So that's the law. If it's a group health plan wellness program, they're subject to the ACA, and that's one of the 5 factors in the 5-factor test is the reasonable alternative standard.
Can you offer a gift card to employees who receive a COVID shot? I mean,
all right.
Who's going to object, right?
Yeah.
So, I mean, the thing is, they're not trying to catch you. They're trying to catch the Yales of the world. Activity or clinical, ask employees to see their physician. No specifics, just verify that you saw your physician.
That's a medical exam.
That's a medical exam. Yeah.
So clinical.
Right. But what actually, it says ask. If it's just ask, you're fine, right? It's that.
Well, you're not in violation, but it is a medical exam. So
it is a medical exam.
It's the way the question's phrased, it falls into the voluntary space. So they're fine.
Yeah, you can say, go get a checkup if you're over a certain, well, actually they can tell anybody, but if people over a certain age or, risk factors should absolutely be getting their checkups. And then the question came up of de minimis. So gift cards, it's likely whatever rules come out would be de minimis. The de minimis would be allowed for anything probably.
Mm-hmm.
So yeah, you can give out $20 gift card. Nobody really knows where the line is, except it's 2 figures for sure. It's not 3 figures. It's probably lower 2 figures. So yeah, low denomination gift cards, T-shirts, have at it, folks. You'll be perfectly fine. And let's see, we've got time for one more, and we will get. Oh no, it says, how does that reconcile with the EEOC saying that employer can make COVID vaccine mandatory? Employer can make COVID vaccine mandatory.
Yeah.
We're not going to be able to get to these. There are just too many of them, which is the truly a first world problem, having close to 900 people on your webinar. So with that, I think we will close it out. We promise we will get all the questions answered. It might take a couple of days because there's so many of them, but thank you very much. Barbara, thank you so much.
You're welcome.
Mark, you want to just close it out here?
Yes. As Al mentioned before, we're going to be sending everybody a copy of the slide deck. The links will be live, and also a recording of this webinar. So, and that'll go out in about 24 hours from the start of the webinar. So expect to get that. And on there is our contact information. If there's any additional questions, please feel, don't hesitate to reach out and contact us with any more questions. And thank you, Barbara, for joining us today. Thank you, Al. And thank you, all of the attendees, for joining us today and spending this hour with us.
Thanks, everyone.
Bye, everybody.